Oyez, oyez, oyez. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. You may be seated.
Good morning. Just a reminder that unless your case upon motion or by order of the court has been excluded from being posted on the internet, the oral arguments are live streamed and then will be posted on the AOC website. So just information for you to keep in mind. Call the first case, please.
Greywood Crossing Owners Association versus Barbara Holleman et al.
Good morning, Your Honors.
Good morning. I'm here from the appellant.
Your Honor, Arthur Knight of the Knoxville Bar. I will not require rebuttal time. This case was filed originally October the 9th, 2020. Ms. Holleman acted pro se for approximately 4 years. This is a squabble that ended up into a much more serious situation with unpaid assessments and now a judicial sale of her condominium unit. I got retained for her appeal that she appealed based upon Judge Ash's motion, order on motions that was, I think, issued August the 28th of 2020. She answered, she counterclaimed, she lost her trial, her counterclaim was dismissed. She's filed several things. The court can note that the record is extremely voluminous. I know that the court, at least the precedent of the court, is to grant pro se litigants latitude, but they're still expected to follow the rules and procedures of the court. In this situation, what we have is a direct suit for unpaid assessments. She wasn't making them. I think she had issues with her condominium unit. I think she had photographs. She had issues, but whatever she was not able to or did not properly present those to the trial court. I know she had several discussions. I was not involved during the trial court proceedings, and I do know that initially, in the alternative, the plaintiff pled for the judicial sale of her condominium unit. That's an equitable remedy, and I think it's a little drastic in this situation. If anything, Ms. Holleman should be held to pay her assessments, do whatever needs to be done at law, and remain in her condominium unit.
The trial court awarded the Homeowners Association a monetary judgment, which she didn't pay. Then the court ordered that she list her property for sale, which she didn't do. What else can the trial court do to provide a remedy to the association?
I'm not sure, Your Honor. I know the trial court required her to post a $25,000 bond, which she did, just in order to appeal his order of August the 28th. I do concede that Article 5 of the condominium units, rules and regulations provide for the sale of her property. Frankly, down below, she probably should have had the advice of counsel. She didn't. She was pro se. She proceeded. She fought. She lost, and that's why we're here.
Anything else, counsel?
No.
Thank you. We're here from the appellee.
Good morning, Your Honors.
Good morning.
I'm Reese Brassler. I'm here representing Greywood Crossing Owners Association. I don't think I need to reserve any time for rebuttal. As I'd set forth in my brief, the court should confirm the trial court's ruling because the appellant's waived her challenges concerning the order of judicial sale. She's also waived her argument concerning the court's award of specific performance. And she's failed to demonstrate any way that the trial court abused its discretion in granting the Rule 70 motion of the association or denying the appellant's Rule 60 motion. Before jumping into the argument on those points, I'd like to review some key facts in the case. As appellant's counsel has stated, this case was filed in October 2020 after a notice of lien was filed on the appellant's apartment in January of 2017. So 3 years of time had passed before the association had actually tried to enforce the lien, and Ms. Holleman had plenty of time to pay her assessments on the association's, the delinquent assessments owed to the association. After the complaint was filed, as you can tell by the record, which is approaching or exceeding 1,000 pages, the case was at times vexatiously litigated, I would say, by the appellant. And there was regularly voluminous filings, including filings on the morning of motion hearings, motions for recusal filed on the date of motion hearings and on the date of the trial. And there was a recusal sought of multiple judges in the case. And I think this is actually something that's happened in past cases involving Mrs. Holleman as well, that I think this court may have had known about. So despite the appellant's best efforts, on October 4th, 2022, the association was able to obtain an order granting the motion for partial summary judgment. That can be found at the record at Volume 2, pages 164 through 195. The court order was entered by Honorable Don R. Ash, who was sitting by designation after Ms. Holleman had asked for Chancellor Weaver to be recused from the case. The order ordered that the attorney's fees and costs and delinquent assessments owed to the association be paid to the association by Ms. Holleman, and that Ms. Holleman list the property for sale within 30 days. Notably, in the complaint on sworn account, the association had asked for the judicial sale of the property. It's been stated that this was an alternative request or an alternative remedy that the association requested, but the association asked for the award of delinquent assessments, and it asked for the judicial sale of the property so that the delinquent assessments would be paid. Given the history with the property owner, it was unclear and seemingly doubtful that they would ever get paid this money. So that's why the judicial sale was asked for. And as it was admitted, that Article 5 of the Declaration does provide that the court can order a judicial sale of the property. So that happened in October, and then in December there was a trial that was held on Ms. Holleman's claims. I don't think these things are at issue in this case. I don't think anything's been raised about how the court decided anything in that matter. The appellant has admitted that the appellant failed to put on cogent proof of her case. The appellant failed to follow the rules of civil procedure and evidence, and that the case was involuntarily dismissed at that time. Thereafter, it was expected that Ms. Holleman would put her property for sale, but that did not happen. So the association was required to file in April of 2023 a motion for contempt and a motion for to enforce the decree from the court, which the court eventually granted. In between times, on July 7th, Ms. Holleman filed the Rule 60 motion that's at issue here today. During the hearing on the Rule 60 motion and the Rule 70 motion, the court again granted the association's Rule 70 motion and denied our motion for contempt, also denied the Rule 60 motion. There was two other motions pending by Ms. Holleman at that time that the court kind of grouped into one thing, and the court found essentially the crux of the arguments in appellant's motions was that the court's order should be stricken due to a purported violation of Tennessee Rule of Civil Procedure 5.01. Because the designation order from the Tennessee Supreme Court was not served upon the parties, and because certain letters appellant claimed to have not received in the case that relate to notice. The court had found, though, that the appellant had been mailed, and there was evidence she'd received or either mishandled or thrown away certain mail correspondence from the court because she believed them to be letters advancing political agendas or campaigns.
Does the record indicate that the order appointing Judge Ash was mailed to her?
I believe so, Your Honor. We received a letter from Judge Ash's office that is indicated in the record, stating that Judge Ash was designated by the Supreme Court, and that we would have a status conference on a certain day. Judge Ash had stated in multiple of his orders in the trial court that he had mailed that letter to Ms. Holleman at her address, which is the address at issue in the case, the address that she had included herself on certificates of service. So she knew about the initial status conference, even if the designation order was not mailed directly to the parties or entered by the court. She was aware of the first status conference that happened in 2022 or 2021. So this appeal followed after that, and again, we argue that the appellant's waived her challenges here. She failed to raise in the trial court any issue with the judicial sale. She has failed to argue that in her lead brief, I would argue as well. She also failed to raise the argument concerning specific performance in the trial level by failing to raise it at the trial level. And she's failed to demonstrate that the trial court abused their discretion in granting the Rule 70 motion or denying the Rule 60 motion. With respect to the first argument, although appellants raised the issue of the judicial sale and states that the trial court erred by granting the judicial sale, there's no actual argument supporting the brief. In the argument in the brief, there's no actual argument supporting that contention and that issue. Rule 27A7 of the Tennessee Rules of Appellate Procedure requires arguments to include the contentions of the appellant, the reasons for them, including the reasons why they require appellate relief, and then citations to authorities and references to the record to support those arguments. So although the argument references the August 28th, 2023 order for judicial sale, the support for that argument is only that appellant was pro se at the trial level, that as a result of her pro se status, she failed to submit cogent damages, and that the pro se litigant should be afforded some sort of latitude at the trial court. This is only supported by a citation to Young v. Barrow, which explicitly undermines their argument, in my opinion, because it states that the courts must not excuse pro se litigants from complying with the same substantive and procedural rules that represented parties are expected to follow. So, in my opinion, if the court were to find that some sort of latitude should be given under these circumstances, that pro se litigants should be allowed to disobey or disregard the rules of civil procedure, I think that would eviscerate the rules of civil procedure and the rules of evidence, and it would actually put represented litigants at a stark disadvantage in front of courts. If the court does find that the appellant's argument is contained in there and supports the issue of the judicial sale, we would argue that the argument does not comply with Tennessee Court of Appeal Rule 6A, which requires arguments to contain a statement by the appellant of the alleged error, a statement showing how the alleged error was seasonably called to the attention of the trial judge, with citation to the record, the challenge to the error, a statement reciting where appellant was prejudiced by the error, and a statement of each determinative fact relied upon with citation to the record. So in this case, appellant's brief does not have any citation to the record, does not state anywhere that appellant seasonably called any sort of error out to the trial court. Appellant did not raise at the trial court any issue with the judicial sale order, any issue with the specific performance order. Instead, her Rule 60 motion, her motion for relief, and motion to strike all related to certain procedural aspects or certain notice aspects which the court found to not be valid. I'd also argued that the appellant has waived her argument concerning the degree of specific performance by failing to raise that in the trial court. Again, she argues in her brief that the trial court erred in awarding specific performance because it's an equitable remedy that's not awarded unless, presumably money damages are presumed to be an inadequate remedy. I think there's some typographical errors that made the argument difficult to quite understand. But the association's position is that the substantive basis of that argument is of no significance since, again, it was waived. Rule 36 of the Tennessee Rules of Appellate Procedure states that nothing in the rule shall be construed as requiring relief be granted to a party who failed to take whatever action was reasonably available to prevent or nullify the harmful effect of an error. The rule further states that a final judgment shall not be set aside unless, considering the whole record, error involving a substantial right more probably than not affected the judgment or result in the precedence or prejudice to the judicial process. So essentially, the record is clear that the plaintiff failed to take action in the trial court to preserve the argument she now raises on appeal related to specific performance. And Tennessee courts have long held that arguments not raised before the trial court are waived on appeal. Even if appellant had raised such issue in the trial court, any alleged error by the trial court in ordering appellant to sell her house would not have any effect on the actual judgment because the association was entitled to the judicial sale of the property. So no matter how the trial court got to the position of a judicial sale, it was the association was entitled to that in the first place. So if there's issues with the court ordering specific performance, the reality is the judicial sale was going to occur anywhere. House was going to be sold anyway based on the outcome of the case and based on the plain language of the declaration. And again, the Rule 60 motion by appellant only contains references to notice provisions and to Rule 5.01, and basically states she didn't receive certain mail or that she wasn't given the order of designation by the court. Furthermore, appellant has failed to show that the trial court erred in granting the Rule 70 motion. Appellant's argument on appeal concerning the trial court's order granting the Rule 70 motion essentially states that although the association was empowered to seek the sale of the property as a result of the assessments, the trial court should not have awarded that relief because appellant was pro se and money damages would be an adequate remedy. Again, money damages argument and the argument concerning specific performance was not raised at the trial level. It was not ever raised. There's nothing in the record that indicates that she had ever brought this up at the trial level, and therefore it can't be argued before the Court of Appeals now. Furthermore, appellant's argument has to fail because she admits that the declaration provides for the sale of the property, that she failed to comply with the procedural and evidentiary rules required to prevail in her claims, and because pro se litigants are required to follow the same substantive and procedural rules as represented litigants. Even looking past the obvious public policy issues with accepting these arguments, it must fail because she has not shown that the trial court abused her discretion in ordering the judicial sale. Again, as admitted by the appellant, Article 5 of the declaration provides for the judicial sale of the property within the association by the association to enforce any assessments liens. The association requested in its complaint on sworn account and in its motion for partial summary judgment that it be awarded damages for the delinquent assessments and an order for the judicial sale of the property. Accordingly, the remedy awarded was actually a contractual remedy to the extent that there was any error, which we contend there was not. With the grounds upon which the court ordered the judicial sale, it was a harmless error because it did not affect the ultimate judgment. This is the whole purpose of Tennessee Rule of Appellate Procedure 36, to ensure that any minor errors in the court's rulings are not used to overturn entire cases. Finally, the trial court did not err in denying appellant's Rule 60 motion, and appellant has failed to show that the court abused its discretion in denying the same. Appellant's brief fails to show any grounds upon which the trial court erred, much less abused its discretion in denying the Rule 60 motion. The appellant's brief, Rule 60.01 is intended to provide an avenue for relief to litigants when a court's judgment or order, either standing alone or when viewed in connection with other portions of the record, shows facially that it contains errors from an oversight or omission. There have been no facial errors pointed to in any order of the trial court. Rule 60.02 provides relief from judgment or orders entered as a result of mistake, fraud, or other reasons justifying relief. While it's unclear exactly what is being requested here, whether the relief under Rule 60.02 was being requested under a catch-all provision in Rule 60.02, that rule is intended to be employed in only the most unique and exceptional circumstances, and that's not the case here. The only argument advanced by the appellant that could be presumed to support this issue in her brief is that the court ordered her to sell her property. And again, this argument was not raised before the trial court. The court's order of specific performance was not raised before the trial court. Accordingly, we would respectfully request that this court affirm the trial court's ruling and tax the cost of the appeal to the plaintiff and award the association its reasonable attorney's fees incurred in connection with this appeal. Thank you, Your Honors.
Of course, thanks to counsel for both sides. We appreciate your arguments this morning. Call the next case, please.
Michael Darren Franz et al. Versus Oscar Films.